Hello, future BC real estate agents. Welcome to this practice session on Chapter 18, Local Government Law. Whether you're studying for an exam, brushing up on your knowledge, or just curious about how local governments work in British Columbia, you're in the right place. In this video, we'll go through 20 practice questions to test your understanding of key concepts like municipal powers, bylaws, governance structures, and legal responsibilities. I'll read each question. You can pause the video, think, and then play the video to get the correct answer and a brief explanation. So, grab a notebook, stay focused, and let's get started. Question 1. Which of the following is not within the powers granted to the Agricultural Land Commission under the Agricultural Land Commission Act? Correct choice is B. The ability to expropriate land and add it to the Agricultural Land Reserve. Explanation. The Agricultural Land Commission, ALC, under the Agricultural Land Commission Act, has various powers to regulate land within the Agricultural Land Reserve, ALR. However, it does not have the power to expropriate land to add it to the ALR. Expropriation is typically a power reserved for government authorities for public purposes, such as infrastructure projects. Why the other options are true. A. The ability to exclude land from an agricultural land reserve. The ALC can approve applications to remove land from the ALR under certain conditions, such as when it is no longer suitable for agriculture. C. The ability to pass regulations affecting agricultural reserve land. The ALC can set policies and regulations regarding land use, subdivision, and non-farm uses within the LR. D. The ability to allow subdivision of agricultural reserve land. The ALC can approve applications to subdivide ALR land, but only if it aligns with agricultural priorities. Final answer. The ALC does not have the power to expropriate land for the ALR, making option B the correct choice. Question 2. Which of the following is not an example of an issue that could be addressed by a zoning bylaw? The correct answer, false statement, is C. The development and operation of airports. Explanation. Airports are under federal jurisdiction, meaning their development and operation are regulated by the federal government, not local zoning by laws. The Aeronautics Act and Transport Canada oversee airports, so municipalities cannot regulate them through zoning bylaws. Why the other options are true, can be regulated by zoning bylaws. A. The legality of secondary suites. Local governments can regulate whether secondary suites, e.g. basement apartments, are allowed in residential areas. B. The regulation of off-street parking and loading. Zoning bylaws often specify parking requirements for residential, commercial, and industrial properties. D. The regulation of short-term rental accommodations. Many municipalities use zoning bylaws to regulate Airbnb-style rentals, including where they are allowed and for how long. Final answer. The development and operation of airports is a federal matter, so option C is the correct choice. Question 3. Which one of the following is not a rationale for government regulation of land use? The correct answer, false statement, is C. Limiting the power of land developers. Explanation. Government regulation of land use is not meant to simply limit the power of developers. Instead, it aims to balance development with community needs, environmental protection, and public safety. While land use regulations may indirectly restrict developers, their primary purpose is not to limit their power but to ensure responsible development. Why the other options are true, valid rationales for land use regulation. A. Protection of property values. Zoning laws help prevent incompatible land uses, e.g. a factory in a residential area, to protect property values. B. Public health and safety. Building codes, zoning laws, and environmental regulations help prevent hazards like flooding, pollution, or overcrowding. D. Conservation of natural resources. Governments regulate land use to preserve forests, wetlands, water sources, and farmland for future generations. Final answer. Land use regulations are not primarily intended to limit developer power, making option C the correct choice. Question 4. Which of the following is an example of a legal non-conforming use? The correct answer is D. A long-established factory in an area that has just been rezoned from industrial to residential. Explanation. A legal non-conforming use refers to a property that was legally built and used under previous zoning laws but no longer complies after zoning changes. The property is grandfathered in and allowed to continue operating under its previous use, but it generally cannot be expanded or significantly altered. Why the other options are incorrect. A. A basement suite in a single-family zone near a university. Incorrect, because the suite was built after the zoning restriction was in place. Even though the municipality is aware of it, it remains illegal unless formally approved. B. A 25-year-old grocery store in an area that was rezoned from multifamily to single-family 2 years ago. Incorrect, because the grocery store was already non-compliant before the zoning change. For a use to be legal non-conforming, it must have originally complied with zoning laws when it was built. C. A restaurant in a rezoned commercial to residential area that is expanding. Incorrect, because while the restaurant may be legally non-conforming, expanding the building violates zoning laws, as expansions of non-conforming uses are typically not allowed unless specifically approved. Final answer: the factory was originally compliant with industrial zoning, and when the area was rezoned residential, it became a legal non-conforming use. Therefore, option D is correct. Question 5. The Local Government Act creates 3 different levels of local law. Which of the following is not one of these levels of local law? The correct answer, not a level of local law, is B, Local Enterprise Zone. Explanation. The Local Government Act in Canada, particularly in British Columbia, does not create local enterprise zones as a level of local law. Enterprise zones are typically economic development tools, not government levels. The 3 levels of local law under the Act: A. Local Improvement District. These are special-purpose local governments that provide specific services, such as water, fire protection, or street lighting, to certain areas. C. Regional District. Regional districts manage services that affect multiple municipalities, such as land use planning, waste management, and regional parks. D. Municipality. Municipalities, cities, towns, or villages have local councils that create bylaws for zoning, business licensing, and other local matters. Final answer. Since local enterprise zones are not a level of local law, option B is correct. Question 6. Jake has owned an industrial toxic waste disposal plant in Vancouver for a number of years. The area in which the plant is located was rezoned 1 year ago, and the applicable zoning bylaws do not permit a waste disposal land use. The residents of Vancouver are lobbying the city council to close down the plant. Which of the following statements is true? The correct answer is A. The plant is a legal non-conforming use of the land that may continue indefinitely. Explanation. Since Jake's industrial toxic waste disposal plant was legally operating before the zoning change, it qualifies as a legal non-conforming use, also known as a grandfathered use. A legal non-conforming use may continue indefinitely unless the use is discontinued for a specified period, e.g., 6 months to a year, depending on local bylaws. The building is destroyed beyond a certain percentage, often 75% or more. The owner voluntarily changes the use to something compliant. Why the other options are incorrect. B. The plant is a legal non-conforming use that may continue until Jake sells the property. Incorrect, because legal non-conforming status stays with the land, not the owner. A new buyer can continue the same non-conforming use. C. The Planning Act establishes the circumstances under which non-conforming uses may continue. Incorrect, because in British Columbia, the Local Government Act, not the Planning Act, regulates non-conforming uses. D. A buyer would require Jake to obtain a bylaw amendment, land use contract, to make the use legal. Incorrect, because land use contracts can no longer be created in British Columbia. Instead, Jake could either continue operating under the legal non-conforming use rules, apply for a rezoning, or seek a variance or special permit from the city. Final answer. The plant was legal before the zoning change and may continue indefinitely, making option A correct. Question 7. Which answer most accurately describes an official community plan? The correct answer is D. An official community plan states the objectives and policies of a local government that guide future decisions on planning and land use management, which represents the longer-term vision for the community. Explanation. An official community plan, OCP, is a policy document adopted by a municipal or regional government to guide long-term land use, development, and community planning. It sets out broad objectives rather than enforceable laws, meaning future zoning bylaws and planning decisions must align with the OCP, but it does not require immediate implementation of every detail. Why the other options are incorrect. A. An official community plan is a policy statement that must be carried out in every detail by the council. Incorrect, because while bylaws and development decisions must align with the OCP, the municipality is not obligated to implement every detail exactly as written. B. When an OCP is adopted, existing zoning bylaws that do not conform are suspended. Incorrect, because existing zoning bylaws remain in effect. The OCP only influences future zoning and planning decisions. C. An OCP is a plan created by a regional district for a municipality regardless of the municipal council's views. Incorrect, because municipal councils play a key role in approving their own OCPS, and regional districts cannot unilaterally impose a plan on a municipality. Final answer. An OCP guides long-term land use planning by outlining objectives and policies for future decision-making, making option D correct. Question 8. A board of variance is a board established to. The correct answer is D. Permit a minor deviation from a zoning bylaw for an individual property owner. Explanation. A board of variance is an independent body required in any municipality that has adopted a zoning bylaw. It exists to provide relief from zoning regulations in cases where strict enforcement would cause undue hardship. The board can approve minor variances to zoning bylaws but cannot fundamentally change zoning policies. Why the other options are incorrect. A. Ensure that actions by municipalities are not at variance with the Local Government Act. Incorrect, because a board of variance does not enforce the Local Government Act. Instead, it focuses on granting exceptions to zoning bylaws. B. Settle boundary line disputes between private parties. Incorrect, because boundary disputes between private landowners are civil matters and are typically resolved through surveys, agreements, or court proceedings, not a board of variance. C. Ensure that all non-conforming uses cease within 6 months after a change in a zoning bylaw. Incorrect, because legal non-conforming uses, grandfathered uses, are generally allowed to continue indefinitely unless abandoned or destroyed. Final answer. A board of variance allows minor deviations from zoning bylaws in cases of undue hardship, making option D correct. Question 9. Which of the following statements concerning government regulations of privately owned land is true? Correct answer. C. Local governments derive their powers to regulate privately owned land use from the provincial government and may only exercise the specific powers delegated to them. Explanation. Under the Constitution Act, 1867, provincial governments were granted jurisdiction over private property matters, including land use regulations. However, they can delegate some of these powers to local governments, which must operate within the specific powers granted by the province. Why the other options are incorrect. A. The provincial government and the federal government together have legislative authority over most privately owned land in Canada. Incorrect, because land use regulation falls under provincial jurisdiction, not federal. The federal government only regulates specific land types, e.g., national parks, indigenous land, military bases. B. The provincial governments have delegated their authority over privately owned land to local governments, and at present, they retain no authority for regulating uses of privately owned land within the provinces. Incorrect, because provinces still retain some authority over land use. For example, British Columbia's Agricultural Land Commission Act regulates farmland use, meaning the province has not fully given up its control. D. In British Columbia, all local governments derive their authority to control privately owned land use from the Local Government Act. Incorrect, because other provincial legislation, such as the Heritage Conservation Act, also grants local governments authority over land use restrictions, e.g., heritage site preservation. Final answer, option C, is correct. Local governments only have the powers delegated to them by the provincial government and cannot regulate beyond that authority. Question 10. Which of the following is not a part of a standard zoning bylaw? Correct answer, D. A consolidation of all amendments to the bylaw adopted up until the time of consolidation. Explanation. A standard zoning bylaw typically includes 1. The official zoning map shows how land is divided into different zoning districts. 2. Restrictions as to land use, defines what activities and buildings are allowed in each zone. 3. Schedules outlining regulations, lists the specific rules and requirements, e.g., height limits, density, lot sizes, for each zoning district. However, a consolidation of all past amendments is not a standard part of a zoning bylaw. While municipalities periodically consolidate bylaws to make them easier to read, the consolidation itself is not an official component of the zoning bylaw. Why the other options are incorrect. A. The official zoning map, incorrect. This is an essential part of a zoning bylaw, showing different zoning districts. B. Restrictions as to land use, incorrect. Every zoning bylaw must define permitted land uses, e.g. residential, commercial, industrial. C. Schedules outlining regulations, incorrect. These provide detailed rules for each zone, such as setbacks, height restrictions, and lot coverage. Final answer. Option D is correct. A consolidation of amendments is not a standard part of a zoning bylaw, even though it helps organize updates. Question 11. Which one of the following is not an activity of a Board of Variance? Correct answer C. To amend a zoning bylaw. Explanation. A Board of Variance has specific powers related to exceptions to existing zoning bylaws, but cannot amend those bylaws. Their role is to grant variances in certain situations where enforcing a bylaw would cause undue hardship to a property owner. Why the other options are incorrect. A. To permit a structural alteration to a building used for a non-conforming use. Incorrect. The Board of Variance can allow minor alterations to structures that are used for non-conforming uses when required. B. To hear an appeal where the enforcement of a zoning bylaw will cause undue hardship. Incorrect. The Board of Variance reviews appeals where enforcing a zoning bylaw causes undue hardship on a property owner, and they can make exceptions based on this. D. To establish a time limit within which construction of a minor variance must be completed. Incorrect. The board can set time limits for completing the construction of projects with minor variances granted. Final answer. Option C is correct because amending a zoning bylaw is not within the authority of the Board of Variance. That power lies with the municipal council or regional district. Question 12. A Board of Variance is, correct answer C, a board established by municipalities to determine whether a zoning bylaw creates undue hardships on property owners. Explanation. A Board of Variance is a local government body that can determine whether the enforcement of a zoning bylaw would create undue hardship for property owners. If the hardship is significant, the board has the authority to grant minor variances from the bylaw. Why the other options are incorrect. A. A provincial board charged with the responsibility of seeing that actions by municipalities comply with the Local Government Act. Incorrect. A Board of Variance is a municipal body, not a provincial one, and it does not have the duty to enforce the Local Government Act across municipalities. B. A board established by municipalities with the power to amend property assessments. Incorrect. A Board of Variance does not have the authority to amend property assessments. This task is handled by assessment authorities or boards of review. D. A board established by municipalities to settle boundary line disputes between private parties. Incorrect. A Board of Variance is not involved in boundary line disputes. It only grants minor variances from zoning bylaws, not resolving property disputes. Option C is correct because a Board of Variance's main role is to determine if a zoning bylaw causes undue hardship and to grant minor exceptions when justified. Question 13. Which of the following topics would not be found on an official community plan? Correct answer C. The location, amount, type, and density of residential development required to meet anticipated housing needs over the next year. Explanation. An official community plan, OCP, is a long-term planning tool that sets out the vision for a community's growth and development. It generally addresses the following: restrictions on land use, especially for hazardous conditions; infrastructure planning such as highways, sewers, and water lines; public facilities like parks, libraries, and community centers. However, the OCP typically plans for the next 5 years or more, not just the upcoming year. It is a long-term strategy, so C, the location, amount, type, and density of residential development required to meet housing needs for just the next year would not be a typical topic for an OCP. Instead, it would be addressed in long-term housing strategies, projections, or specific zoning amendments. Why the other options are correct. A. Restrictions on the use of land that is subject to hazardous conditions, OCPS, often include hazard management, addressing areas that may be vulnerable to flooding, landslides, or other natural hazards. B. The location and phasing of major highways, sewers, and water lines. Infrastructure planning is a core aspect of OCPS to ensure proper development of transportation and utilities. D. The location and type of present and proposed public facilities, OCPS, often include strategies for public facilities, ensuring there's adequate space and services for future growth. Final answer, option C, is correct because the OCP generally plans for the next 5 years or more and does not focus on just 1 year of residential development needs. Question 14. Your client, Bard, is a developer who owns land in an area zoned for single-family residences. He wants to subdivide his 2.5-acre lot and build two 24-unit condominium projects on the land. Bard seeks your expert advice about how to overcome the land use bylaw obstacles that could prohibit the land development. You correctly advise Bard that correct answer B, a public hearing must be held by the municipal council prior to a change in the permitted land use or density under a zoning bylaw. Explanation. When Bard wants to develop his land in a way that doesn't conform to the current zoning, such as subdividing it for a condominium project, he would need to apply for a zoning bylaw amendment. This process requires that a public hearing be held, allowing local residents and stakeholders to voice their concerns or support for the proposed changes to the zoning bylaw. This is a legal requirement under municipal law. Why the other options are incorrect. Option A. A legal non-conforming use permit does not apply in this situation. A legal non-conforming use applies when a property was lawfully used for a purpose that is now prohibited by the current zoning laws. Bard's case involves seeking permission to change the zoning to allow something new, condominiums, not maintaining an existing use that is now non-conforming. Option C. The municipal council must hold another public hearing if it decides to further amend a zoning bylaw. It cannot make changes to the zoning without another public hearing if the changes affect the public's interest in the land use. Option D. Since options A and C are incorrect, option D, which claims all statements are true, is also incorrect. Final answer. Option B is correct because a public hearing is required before a zoning bylaw amendment can be passed, especially when changing the land use or density. Question 15. Listed below is one of the most important powers given to municipal councils in regulating the subdivision of land. Identify it. Correct answer, D. They may require that highways of a prescribed standard be provided as well as street lighting and underground wiring. Explanation. Municipal councils have significant authority when it comes to regulating land subdivisions, and one of their key powers is to ensure that the infrastructure necessary for the development is in place. This includes highways, street lighting, underground wiring, and other essential services like water, sewer systems, and fire hydrants. This regulation ensures that new subdivisions are properly integrated into the existing municipal infrastructure. Why the other options are incorrect. Option A. Requiring cable television services for all lots in a subdivision is not a standard regulation that municipalities can mandate under subdivision bylaws. Municipal regulations focus on more essential infrastructure and public services. Option B. While municipalities can have certain construction standards, requiring that residential units exceed a specified construction value is not typically included in the powers granted under subdivision laws. Subdivisions focus more on land usage, infrastructure, and service provisions. Option C. Restricting the number of lots that can be sold to a single buyer to prevent speculation is not a common power for municipal councils under subdivision laws. Municipalities focus more on ensuring that subdivisions meet infrastructure and public safety standards. Final answer. Subdivisions. Question 16. Before adopting, amending, or repealing a zoning bylaw, a municipal council, as a matter of policy, will. Correct answer. D. Hold a public hearing. Explanation. Before adopting, amending, or repealing a zoning bylaw, a municipal council must hold a public hearing. This is a key step in ensuring that the public has the opportunity to provide feedback on proposed changes that could affect their properties or the community. Why the other options are incorrect. Option 1. The federal government does not approve municipal zoning bylaws. Zoning is a power delegated to local governments by the provincial government. Option 2. While the provincial government delegates zoning authority to municipalities, it does not have to approve individual zoning bylaws before adoption. The local government has autonomy in making these decisions, though it must follow the applicable legislation. Option 3. Municipal councils typically provide notice, but it's usually sent to affected property owners or neighboring properties rather than requiring a blanket 3-month written notice to the public. The public hearing is the main form of notice and input. Final answer. Option D is correct because holding a public hearing is required before adopting, amending, or repealing a zoning bylaw to ensure that the community has input. Question 17. Most zoning bylaws include density restrictions. Which of the following is not a method of measuring density? Correct answer. D. Prescribing the maximum lot area per dwelling. Explanation. Prescribing the maximum lot area per dwelling is not a method used to measure density. Instead, it refers to a zoning regulation that could limit how large a lot can be relative to the number of dwellings on it, which is more related to land use and development restrictions rather than density measurement. Why the other options are incorrect? Option A. The total floor area of the building in relation to the size of the lot is a valid way to measure density, usually called floor space ratio, FSR, or floor area ratio, FAR. This method compares the total floor space of a building to the size of the land it's built on. Option B. The floor area ratio, FAR, is another valid method for measuring density. It is the ratio of the total floor area of a building to the area of the lot. Option C. The number of dwelling units per hectare is a standard density measure, particularly for residential areas. It shows how many units can be built per unit of land. Final answer. Option D is correct because prescribing the maximum lot area per dwelling does not measure density, whereas the other options are standard ways of measuring it. Question 18. A property owner is making an application to the municipal council to amend a zoning bylaw. Which of the following steps is not a part of the rezoning process? Correct answer. B. According to the Local Government Act, the municipal council must wait at least 6 months before approving the amendment. Explanation. The Local Government Act does not require a municipal council to wait 6 months before approving a zoning bylaw amendment. This step is not a part of the rezoning process, which makes option B the correct answer. Why the other options are incorrect? Option 1. The municipal council must vote in favor of the amendment on 4 different occasions is correct. The rezoning process generally requires 4 readings with votes at each stage. Option 3. The applicant may be required to donate a portion of their land to the municipality for a park or pay for road widening. This is correct. Local governments often require applicants to contribute to public amenities or infrastructure improvements as part of the rezoning or subdivision process. Option 4. The applicant may be required to give a presentation about the amendment and answer questions from the municipal council at a public hearing. This is correct. Public hearings are an essential part of the process, and the applicant may be asked to present their case. Final answer. Option B is correct because there is no requirement under the Local Government Act for a municipal council to wait 6 months before approving a zoning amendment. Question 19. The Local Government Act permits a council to enact certain bylaws relevant to planning. Which of the following areas is not regulated by local government? Correct answer D. Airports. Airports are not regulated by the local government. Explanation. The federal government has exclusive jurisdiction over the development and operation of airports, making option D the correct answer. Why the other options are incorrect? Option 1. Land use zoning is regulated by local government. Municipal councils have the authority to regulate land use through zoning bylaws. Option 2. Subdivision regulation is also regulated by local government. Local governments can create bylaws that govern the subdivision of land within their jurisdiction. Option 3. Building regulations are regulated by local government. Municipal councils can pass bylaws concerning the construction, safety, and maintenance of buildings. Final answer. Option D is correct because the regulation of airports falls under the federal government, not local governments. Question 20. Which of the following functions can a zoning bylaw perform? Correct answer. D. A zoning bylaw may do all of the above. Explanation. A zoning bylaw can indeed perform all of the following functions. Option 1. It can divide the area into zones, such as residential, commercial, industrial, etc., to manage land use. Option 2. It can regulate the use of land, specifying what types of activities are allowed in each zone, e.g., residential use, commercial use. Option 3. It can regulate the number of buildings that can be built on a lot, ensuring appropriate development density and infrastructure support. Final answer. Option 4 is correct because zoning bylaws can handle all the functions listed in options 1, 2, and 3.